The doctor accused of trying to kill his wife in an alleged cliff push, syringe, rock attack out in Hawaii is now trying to have the case thrown out. And I will tell you some very, very interesting arguments that may work. We're going to bring on an expert in criminal law to discuss. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, I got to tell you about something that we use here on Sidebar that I think could be very, very useful to you. It is Truth Finder. It is the powerful public record search service that we use to do research here on Law and Crime. But for you, you plug in a name, you get address information, you get criminal history, and let me just say, that can give you some peace of mind. Truth Finder is one of the largest public record search services in the United States, and with a paid subscription, you can get access to unlimited reports about almost anyone, and that includes looking up registered sex offenders in your area too. So stay informed, stay safe, check public records with Truth Finder now at truthfinder.com/LC Sidebar. Big legal update on a story that we've covered before here on Sidebar, and it concerns anesthesiologist Dr. Gerhardt Konig, who is charged with second-degree attempted murder for allegedly trying to throw his wife off the side of a cliff out in Hawaii and then allegedly proceeding to beat her with a rock and try to inject her with a syringe. Now, his attorney is trying to get this whole case thrown out. The question is, will it work? I will tell you, I don't know. After reading some of this, it makes you pause and wonder. Now, it is rare. We'll talk about this. It is rare to get these motions, but there might be something here. So we're going to get into all that. We're going to get into all the arguments. We're going to get into the new court filings. There's also something from the prosecution that we have to talk about. It's really, really interesting. But obviously, I can't get into any of that without giving you the backstory, right? So we have Gerhardt and his wife, Arielle Konig. They lived in a reported $1.5 million home in a private community out in the West Maui Mountains out in Hawaii. This is according to People. He worked at the Maui Memorial Medical Center in Wailuku. Arielle was a stay-at-home mom, but also worked as apparently a nuclear engineer. But there were reported issues in their marriage. Gerhardt had apparently accused Arielle of cheating on him. This was per a court filing, a petition for a protective order that she filed against him after this alleged attack, which we're going to get into. But in her original petition for the temporary restraining order, according to the Associated Press, Arielle accused Gerhardt of sexually abusing and assaulting her. She also said they had been going to counseling and therapy since he had accused her of having an affair. This alleged infidelity, these problems in their marriage are seemingly going on or allegedly going on. And then you go to March 23rd, 2025. Gerhardt, Arielle, they decide to take a short flight from Maui to Oahu for a getaway, leaving their two sons at home with a nanny. Now, this is to celebrate Arielle's 36th birthday. The next morning, March 24th, according to police paperwork, they go on this hike that Gerhardt allegedly planned at the Palipuka hiking trail. Now, it should be noted, and we've previously reported on this trail is closed, but they apparently walked right past the area closed sign, and Gerhardt allegedly asks Arielle to take these selfie pictures despite Arielle reportedly being nervous about being up there in the cliffs, okay? So I'm going to read you verbatim from the official paperwork from police, okay? Quote, Gerhardt continued to ask Arielle several more times to take selfie pictures with Gerhardt at the cliff's edge, which alarmed Arielle due to their marriage having recent problems. As Arielle walked past the cliff's edge and towards Gerhardt, Gerhardt grabbed Arielle's shoulders and attempted to push her towards the edge of the cliff and said, "I'm sick of this bleep. You're a lying bleep." When Arielle reportedly brought up their children in common to try and convince Gerhardt not to push her off the cliff, Gerhardt said, "They're only going to get one of us." As Arielle was being pushed closer to the cliff's edge, she threw herself to the ground in an attempt to stop Gerhardt from pushing her off the cliff's edge and began wrestling with Gerhardt while trying to defend herself. As Arielle wrestled with Gerhardt, Gerhardt got on top of Arielle. While holding Arielle down with one hand, Gerhardt used his other hand and took a syringe and a vial out of his backpack, at which time Arielle was able to get the syringe out of his hands and throw it away from them and scream for help. Arielle described the backpack as a Patagonia brand black one-shoulder bag that Gerhardt usually takes to work. As they kept wrestling, Gerhardt kept trying to pull Arielle towards the cliff's edge as Arielle screamed for help. Arielle continued to remind Gerhardt about their children and his parents while pleading with him to calm down as he appeared to be possibly grabbing another syringe from his backpack. Gerhardt calmed down for a moment before picking up a rock from the ground near Ariel's head and struck Ariel on the head, face, and hand area with the rock about 10 times while using his other hand to grab Ariel's hair, to lift up her head, to bash it into the ground as Ariel screamed for help. It continues. As Gerhardt repeatedly struck Ariel with the rock, two women hikers approached the area, interrupting Gerhardt's attack, prompting Gerhardt to get up and off of Ariel. Now, Ariel allegedly yelled, "He is trying to kill me," when hikers walked by, and they called 911. So the police arrive. Ariel is rushed to a medical center. Gerhardt allegedly flees into the forest, by the way. He was arrested 6 hours later after a manhunt. And according to prosecutors, after he allegedly ran off, Gerhardt, and this is important, Gerhardt allegedly called his adult son and told him that he tried to kill Ariel because she was cheating on him. Keep that in mind. It comes up later. And prosecutors also allege that he told his son he was planning to turn off his phone so police couldn't track it. Now, Ariel reportedly suffered major cuts to her head from this softball-sized lava rock that her husband allegedly beat her with. You have WTAE reporting that she had to have surgery. A few days later, when she'd returned to her home to Maui, she called police to let them know that she'd found something very suspicious in Gerhardt's closet. A warrant reads, quote, Ariel discovered what appeared to be several syringes and several different drug medicine vials. Upon speaking with Ariel via telephone, which was audio recorded, Ariel described the syringes she observed in the Nike fanny pack as clear, regular syringes and described the vials she observed in the Nike fanny pack as hospital vials. And she also revealed that the fanny pack was, quote, Gerhardt's medical bag that he takes with him as he goes to and from work as an anesthesiologist. Now, the fanny pack was collected from the home by officers who immediately shipped it to the island of Oahu. A Honolulu police officer searched it, took photos of what they found inside, reportedly including multiple syringes, multiple vials of different anesthesia medications that are often found in hospitals. Now, obviously, in an unsurprising move, Ariel filed for divorce from Gerhardt, and while she initially pursued that TRO, that temporary restraining order against him, she apparently dropped it, especially with him being locked up behind bars, awaiting trial. Her attorney basically indicated that this is just a way to now focus on the criminal case. So put all that to the side, okay? After a grand jury indicted Gerhardt on attempted second-degree murder and he entered a plea of not guilty, now we have to talk about what his lawyer is doing, okay? Trying to get the case thrown out. Will it work? That's the question. All right, so as I break down the arguments, I want to bring on Philip Dubé, former deputy public defender from LA County. Philip, it's so good to see you. Thanks for coming back on here. Before we even get into the specifics of the arguments, okay? And they're very, very interesting. Before we even get into that, before we even get into the specifics of this case, generally speaking, how successful are motions to dismiss in criminal cases at this stage?
They're never. They're really not.
Never.
No,
Wow.
it's rare. Based on my experience, we very, very rarely get a felony murder or attempt murder kicked at this early stage of the proceedings. It's extraordinarily rare. Now, once in a while, we will get motions granted, but they're not dispositive of the dismissal of the actual charges. It might just chip away at the evidence that's going to be introduced at the trial. But otherwise, no. And even if these motions are successful, the prosecution is going to be able to re-impanel a grand jury and start anew. So it's not as if he's going to walk away. It just means they start over.
Well, I will tell you, there seems to be an effort, at least in one of these motions, to dismiss this case, I believe, with prejudice, right? So it wouldn't be brought back to the grand jury. So let's go through this. I hear you. I know it's rare, but it does happen. It does happen, and I'm curious, is there room here for the charge to be dropped? I want to get into it. So there are two separate motions to dismiss that we're going to talk about. I'm going to take them piece by piece. I want to start with the first motion to dismiss. Now, the first motion to dismiss asserts that there are two different grounds to get the case dismissed, to get the case thrown out. One, the argument is that the prosecution didn't present exculpatory evidence to the grand jury that indicted Gerhardt, meaning evidence tending to show that he's not guilty of the crime. So now your question is probably, what evidence are they talking about? Well, they refer to these physician forms that apparently two doctors completed that the defense here argues shows, in their opinion, that these doctors concluded that Ariel's injuries, quote, did not create a substantial risk of death. Now, why is that important? Let me explain. So the defense argues that in order to prove attempted second-degree murder, you need to show that the defendant took a substantial step to kill with an intent to kill. And the defense argues the prosecution didn't show that. Quote, two doctors examined the complainant shortly after the charged incident allegedly occurred. Both of those doctors opined that her injuries did not create a substantial risk of death. That the defendant allegedly assaulted the complainant with a rock, which Detective Spacek told the grand jury was smaller than a softball, to an extent that failed to create a substantial risk of death, is clearly exculpatory circumstantial evidence that the accused did not harbor the specific intent required to prove attempted murder. By not presenting such clearly exculpatory circumstantial evidence, the state therefore misled the grand jury in a manner that prejudicially undermined the grand jury's independence and impartiality. Now, I will tell you, I looked at the doctor's report, or the apparent doctor's report that's included as an exhibit here, and next to, did the injury create a substantial risk of death, there is a check next to the box that says no. Okay, Philip, over to you. Is this a good argument? Because essentially it would be that there was, I mean, unless I'm wrong, there's really no way he could have killed her with the rock? I mean, couldn't it also be argued that he could have killed her, but remember, it's attempted second degree. He could have killed her, it just didn't complete the act.
That's exactly what the problem is for the good doctor here. And I don't mean the doctor who rendered the opinion. I'm talking about Dr. Konig. The test is not whether he could have caused the death. The test is one of his intent. In other words, when he tried to push her off a cliff, or when he tried to inject her with a syringe, or when he tried to knock her in the head with a rock, what was his intent? And the fact that he was unable to carry out the intent does not necessarily mean he's innocent. It just means he's guilty of an attempt. Because for all we know, what if he would have kept banging her on the head with that rock? What if he would have taken that rock and really slammed it into her head 15, 20, 30, 40 times until she's finally dead? So the fact that maybe she only got struck once or twice, and perhaps the act was thwarted by hikers or people, walking on the trail there, doesn't mean that the act could not have been carried out. The test is one of what was going through his mind at the time. And that was for the grand jury to determine.
Right. So in other words, it would have been different. For example, if someone takes a pillow and hits somebody, that you could be like, there's no way under the law that that is attempted murder, so that the case should be thrown out. But when you're dealing with a rock, or let's say a syringe, or allegedly trying to throw her off the cliff, your opinion is that two things can be true at once, right? A doctor could say there was no substantial risk of death because they're looking at the injuries that she actually sustained, but at the same time, there could have been an intent here to kill her.
Absolutely. And, the real question is, what would have happened if those hikers would not have come along the way? It means he could have potentially gotten the job done, assuming the prosecution is correct in their theory. And if that were the case, it could have potentially gone unsolved, because what likely would have happened is she would have died and her body would have been thrown over the cliff into the Pacific Ocean there, and she may have never even been found. But the test is one of intent. Whether or not the substantial act toward commission of the underlying homicide is actually carried out is irrelevant. All that really matters is, was the act accompanied by that evil intent?
And to this other argument, though, hey, listen, the grand jury didn't see these reports. I guess that's the argument, right? Is this exculpatory information to the extent that it misled the grand jury? The case should be thrown out. What's your opinion on this kind of evidence not being presented to the grand jury? Because some people might say this and wait a second. Grand jury hearing is not a trial. Isn't it kind of one-sided? Isn't it what the prosecution presents? So talk to me about the rule about exculpatory information in a grand jury and whether or not, they have an argument that should have been presented.
Great question. And I think a lot of it depends on how many jurors voted to indict. And I think under Hawaii law, they need 9. If only 9 came back out of the 12, and this evidence could have been presented or should have been presented, there's an argument to be made that less than 9 could have come back, meaning there's not even probable cause, to believe that he even committed the crime, let alone proof beyond a reasonable doubt. And had those reports been presented, it could have tip the balance in favor of not returning a true bill of indictment. Now, on the other hand, again, it goes back to what I said earlier. I don't believe that these reports, even though they do not show a substantial step toward commission of the crime, prove that he could not have done it anyway. All it really proves is thank God that he didn't, and thank God that she survived. But it does not negate or obviate his underlying intent. That's his legal.
Okay, so we put that one to the side. We'll talk about it again in a minute because we'll try to see what we can expect will happen here. But I want to move on to the second ground for dismissal in this first motion to dismiss. And this is, again, argued by Gerhardt's defense. This argument is about hearsay. Now, Philip, real quick, before we get into all this, the specifics of this, in layman's terms, what is hearsay? Why is it bad? Why is it not allowed in a trial? Let's just start there so we're all on the same page.
Here's the bottom line. Hearsay is when you're quoting somebody outside of court in court. You cannot quote people who said stuff outside of court. You need that person to come in and testify. And the reason why is that it's inherently unreliable just to put forth statements from other people without having the opportunity to cross-examine them and test the validity and accuracy and veracity of the statement. So when they're coming in through a third or fourth or fifth party through multiple layers, then it questions whether or not the true fact is being diluted. And you don't want to mislead, particularly a grand jury, as to what was said. Otherwise, you are unnecessarily putting people on trial for crimes that carry life. So I think, in fairness, particularly when the bar is so low anyway, you need to bring in your witnesses and have them testify to what exactly occurred and what exactly was said, and not through third parties.
That's a brilliant explanation, one of the clearest explanations that I've ever heard. I'm happy you laid it out there because, yeah, 100%. Like, it's not fair for a defendant to have to defend himself if you have somebody come in and be like, yeah, John Smith told me that defendant, said he killed her. That's, because again, what's the reliability of that? How do we, test if that's actually true, what the statement was, unless you have that person testify. There are exceptions to certain statements coming in for other purposes, but we're going to put that to the side. Now, let me explain what is happening here. So the defense claims that the prosecution presented misleading hearsay evidence to the grand jury and that the case needs to be thrown out. Now, the defense says that a prosecutor may present hearsay to a grand jury. It just can't be misleading. So here, the defense argues that the state presented triple hearsay when they tried to show that Gerhardt, again, the defendant, allegedly confessed to his son, Emil, about what he tried to do. The defense argues, wait a second, he didn't really say that. So the defense explains that the prosecution presented the testimony of Detective Spacek during the grand jury hearing. And this was about Emil's interview with police. The defense claims that Detective Spacek's testimony, quote, appears to repeat and distort what the detective who interviewed Emil said and what was written in his report, that this distorted what Emil actually said. That might be a little complicated, so let me break it down. The initial issue, before we get into this, is why didn't Emil just, testify during the grand jury in the first place, If there's a question about what he allegedly said, just have him testify. Well, that's problem number one, Just have him testify about what his father allegedly said. That's problem number one because according to the defense, Detective Spacek reportedly told the grand jury that while Emil was told about the grand jury hearing, he wasn't available because he was in Pittsburgh, Pennsylvania, and didn't know when he was going to be back in Hawaii to testify. The defense argues, wait a second, being in Pennsylvania doesn't mean he wasn't available to testify under the law, and for hearsay purposes, he could have testified through video, he could have testified through phone, he could have been subpoenaed by the prosecution. So the prosecution could have gotten him on the record, and just substituting hearsay evidence about what Emil allegedly said, that doesn't cut it. Okay, Philip, before we get into what Emil did or did not say, I got to get to that initial argument. Is the defense right? Is he really not an unavailable witness under the law?
Not at all. He is completely available. unavailability is a term of art. Unavailable doesn't mean that you're otherwise preoccupied, you've got other engagements, you're going on vacation. Unavailability means that either you're mentally infirm or maybe even physically incapable of coming to court, or there's a danger that you're going to flee the jurisdiction, that kind of thing, or they could not otherwise obtain his presence through process after the exercise of due diligence. They didn't have any of that. Instead, he just said over the phone, I can't make it. Well, that doesn't mean you're legally unavailable. So you cannot use that as a pathway to admit all this misleading hearsay at a grand jury. The problem for the good doctor here is that under Hawaii law, hearsay is admissible at grand jury proceedings. However, it cannot be misleading. Okay, the unavailability aspect doesn't necessarily make it misleading. What makes it misleading is exactly what the cop said. In other words, did the good doctor confess to his son, or did the son get everything so muddled and so unclear that it left the jury with the inescapable conclusion that he did confess? And that's a serious allegation, because confessions are the worst evidence against defendants in criminal trials.
100%. So we start with the idea of, okay, defense is making an argument, right? Emil could have testified. So now let's go into the second part, because the defense argues, they allege, basically, the prosecution wanted to make sure that Emil wasn't available to testify so they could strategically get in triple hearsay evidence that makes it falsely look like Gerhardt confessed. This is their allegation. And according to the defense, quote, the transcript of Emil's interview with the MPD detectives does not clearly reflect what the defendant had actually said and admitted. At best, the transcript indicates that Emil assumed that his father had confessed to trying to kill Ariel by pushing her off the cliff. Initially, Emil told the detectives, quote, he said he tried to kill her by pushing her off the cliff. But when pressed further about what words his father had actually used, Emil told the detectives, that's what he said. Well, mostly he just said I tried to kill her, and I'm like, right where they're standing, and they were like on the edge of a cliff, and he was saying he was going to jump, so I assume that's what he meant. They go on to say, what Emil clarified then was that the defendant had not confessed to trying to kill her by pushing her off the cliff, but that Emil had simply assumed that he had tried to kill her by pushing her off the cliff. The defense goes on, quote, Detective McGeough further stated in his report, quote, when asked later if his father admitted to pushing Ariel off the cliff, Emil clarified that his father said it loosely. The transcript of the interview does not reflect that Emil said, quote, his father said it loosely. The gloss that Emil clarified that his father had confessed loosely to trying to kill Ariel by pushing her off the cliff is the detective's paraphrasing and word choices, not Emil's words. Detective McGeough's report thus misrepresents what Emil had said by asserting that Emil said that his father said it loosely, with the it being a confession to trying to push Ariel off the cliff. A fair reading of Emil's clarifying remarks is that Emil assumed that his father had confessed rather than that his father explicitly had confessed. Detective Spacek's grand jury testimony repeats what is written in Detective McGeough's report. And as to Emil's clarification, Detective Spacek told the grand jury, quote, yeah, he was, initially he said that his father Gerhardt told him that he tried to kill Ariel by pushing her off the cliff, but later he kind of clarified that Gerhardt loosely made that comment. Not only did Detective Spacek attribute Detective McGeough's loosely remark to Emil, Detective Spacek also entirely elided Emil's admission that he assumed his father had tried to push Ariel off the cliff rather than that his father had explicitly confessed to doing so. Thus, while Detective McGeough's report, flawed as it is, at least included a remark about Emil assuming something, Detective Spacek's grand jury testimony elided any mention of Emil assuming anything. While the triple hearsay is prejudicially ambiguous and muddled, direct testimony from Emil at the grand jury proceeding could have clarified the ambiguities in the hearsay. Philip, your thoughts?
Correct. And this is why Hawaii law has that rule that while hearsay is admissible to a grand jury, it cannot be misleading. And when you have all these sort of multivalent ways of interpreting what, if anything, Dr. Konig said to the son, what the son said in response, you're leaving a grand jury to have to guess. And remember, it goes back to what I just said earlier. When the bar is so low, namely that it's based on a probable cause finding that the crime was committed and that the doctor committed it, and that you need 9 out of 12, it's very possible that all of this, when you kind of synthesize it, could have actually created fewer than the 9, and they may not have returned a true bill. So what you should do, or what the judge should do in this particular case, is send it back to the grand jury and redo it. And that way, and I don't think that this motion should be granted with prejudice, but I do think it should be granted because I don't think that being slothful, a little indolent, is enough to say that this prosecution should be barred for all time. Because if, in fact, this doctor did this to his wife, he should not escape justice just because a prosecutor was a little lazy in securing a star witness before the grand jury.
And this is coming from somebody who said these motions never get granted. So it's pretty remarkable. And by the way, so the main argument, yes, is that these alleged defects improperly improve the chances that jurors would indict. And in other words, that had the jurors known that the doctors concluded that there wasn't a substantial risk of death and that Gerhardt didn't confess per se, the prosecution's case wouldn't be so strong. Now, as I mentioned, the defense filed a second motion to dismiss. This is a shorter argument. Basically, the argument is, in this one, is the defense wasn't provided the necessary notice or details under the law about the specific charge. For example, what exactly is the, quote, substantial step that was taken for attempted second-degree murder? That the indictment is too general, it's not specific enough. Quote, the generic term substantial step does not indirectly or by inference inform the defendant what the underlying substantial step is. Is it trying to push the complainant off the cliff? Is it trying to inject her with an unknown substance from an unrecovered vial using 2 unrecovered syringes? Or is it striking her with a rock smaller than a softball and inflicting injuries that did not create a substantial risk of death? Obviously, they're putting a little bit of color on their interpretation of the evidence there, but in other words, they're saying the indictment is defective. That Gerhardt, criminal defendant, has a right to know what he's defending himself against. The defense is asking the court either to throw out the case or that the prosecution should be required to file what we call in the law a bill of particulars. Basically, further details of the allegations so they know what they're defending against. What exactly is the substantial step here? Philip, as to this second motion to dismiss, your thoughts?
I do think it has merit because if and when this matter goes to trial, the prosecution's theory is that the death was either going to be brought on by the syringe, the rock, or the shove off the cliff. The defense would be entitled to a unanimity instruction where the jury has to find beyond a reasonable doubt, all of them, that one or more of those substantial steps was carried out. And if you don't have a precise theory on which the prosecution is relying, it puts the defense in the untenable position of having to guess. They should not have to gear up and prepare to sort of deflect all the evidence as against all 3. So they're entitled to clarity on it under due process. So what you do is you send it back for a bill of particulars, but you don't necessarily kick it with prejudice. And the jury can come back. You never know. They might get 4 who says, well, no, we think he was going to do it with a rock. You might get 3 who say, well, we don't know what was in that syringe. Who knows? He could have just had it on him because he's a doctor, you know? And you might get 2 who will come back and say, well, I don't believe he was going to push her off a cliff because I don't think they were close enough to the edge of the cliff anyway. So it's just sort of like a theory that really could not be carried out because physically it would have been impossible. But the bottom line is, I think that this should go back for a bill of particulars so that the defense is on notice of what he needs to defend against at trial.
So in other words, when there's a hearing set for February 9th here, and you're going to hear these arguments regurgitated by the defense, and you'll hear counter arguments from the prosecution probably saying, like, this is not exculpatory information, this wasn't misleading, this witness was unavailable, there was substantial step, it's clear what we're talking about. The judge is going to have to make a decision here. So you believe, when all is said and done, that the judge may actually toss this indictment, have it be sent back to a grand jury with all these things fixed, and maybe even a bill of particulars being ordered so the defense has a better understanding of what the substantial step is. So you, despite saying that these motions are never granted, you think they might be granted in part?
Yeah, just not with prejudice.
Right.
Do you know what I'm saying? So in other words, the prosecution's still going to get another whack. They're not going to be barred. Listen, mistakes are made every day in the justice system by prosecutors. It doesn't mean that they're intentionally trying to deceive the other side. It just means that they got a little sloppy. We're not in the business of punishing either side. In the end, we still want to get to the truth.
Right.
And that's at the heart of our justice system. And to just have an I gotcha moment, you didn't do this right, this didn't get particularized right, therefore the good doctor walked. Not in Hawaii. No way.
Let me ask you one more thing that I have to address. So prosecutors this time, not the defense, the prosecution, they filed something. And it was about how Gerhardt, right, the defendant, reportedly about him not saying anything to police before he was arrested, and how that can be used maybe against him. So, let me be clear, that can maybe be used against him should he testify at trial. So let me explain this. So, as everybody knows, criminal defendants have a right against self-incrimination. However, that doesn't mean, according to the prosecution, that doesn't mean that you choosing to remain silent can't be used as impeachment evidence if you testify, meaning evidence to show you aren't telling the truth. So here, this is what it says, quote, "Here, defendant did not speak to police or any emergency services prior to his arrest on March 24th, 2025, despite having the ability to do so for approximately 8 hours between the incident and his arrest. The jury could infer that a reasonable person situated as the defendant prior to arrest would naturally come forward to share their apparent exculpatory story as soon as possible. His pre-arrest silence has sufficient probative worth bearing on defendant's credibility and therefore is a fair subject for cross-examination. The state may elicit information that he did not provide his story to police prior to arrest as a legitimate issue of credibility subject to the jury's consideration." So in other words, Philip, they're saying, hey, listen, he decides to take the stand and defend himself. They have every right to say, why didn't you tell your story to police? Why didn't you tell your story to first responders? Why weren't you adamant? Oh my gosh, this is not what happened. This is not what happened. Are they right? Can they include that? Can they ask him about that if he takes a stand?
The U.S. Supreme Court held, I think it was back in the 60s, that pre-arrest silence is admissible against a testifying defendant. It's assuming it's relevant. You can't just make stuff up or get into silence that was 3 years before the incident or 3 years before the arrest. But if temporally it's at or around the time of the crime and the arrest, it can come in. The question is, will the court allow it? It's always discretionary. It's not mandatory. But taking the stand is a risky venture, and you do so at your own peril. And he's going to have to be prepared, should he testify, to explain away, because they will ask, why he didn't voluntarily offer up certain information. Now, to be fair to the good doctor, and I say this all the time, even though he's a doctor and he's educated in his field, he's probably never been a criminal suspect before. He probably has no idea what he may know or not know is even relevant to a criminal investigation. And to hold a layperson, a civilian, to that standard, I think is unfair. But unfortunately, those are going to have to be reserved for arguments in your closing to the jury. And he's going to have to explain away every act of silence or omission to avoid a conviction. Because under Hawaii law, these charges carry life.
Philip Dubé, man, I missed you. Great. Thank you so much. Fantastic analysis in this. Always appreciate your insight. Thank you so much.
Thank you back.
That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.